how ridiculous of an argument is this? They got the keys on August 11th, and they moved this big film machine, got it all set up, started making water, and they were doing delivery in the next 2 days. They said, I haven't given them the medical records. Well, I Federal Expressed every medical record that's attached to this motion or reply 3 times. I sent it to him, I sent it to him, and I sent it to him. And I attached the Federal Express invoices to the reply. Good morning, sir.
Good morning, Your Honor. Nicholas Hoffman for UNFI. I'm going to jump around a little bit as I address Mr. Kemp's arguments. I also eventually want to give you a little further context that he didn't give you. But to start out, I'll start out where he started, and that's with the CDC or FDA's Establishment Inspection Report. That's Exhibit 7 to UNFW's opposition. And the key portion that Mr. Kemp pointed you to says, quote, according to Blaine Jones, the firm stopped production at their former Las Vegas location in approximately July or August of 2020 in order to move its operations to the current Henderson, Nevada location. Now, Mr. Kemp went on and read the second sentence, which talks about the further clarification, but I want to give the court some context on why this is drafted like this. And so, during the course of the investigation, it became clear that unfortunately Blaine Jones and Real Water were not being forthcoming with some of the questions they were asked by the investigators. They were asked for paperwork to substantiate when they started the production at the Henderson facility, and they were unable to do so initially. The reason for some of this, eventually Southern Nevada Health District did not believe them. And so Southern Nevada Health District actually went and checked for the water consumption records at the Henderson facility so that they could verify when the actual facility started. The reason why Real Water perhaps wasn't forthcoming is because it was unpermitted. So the Henderson facility was not permitted, the Mesa, Arizona facility was having issues. So they were motivated to not be fully forthcoming with it. But after the investigation, the Southern Nevada Health District did find that they had started earlier. And so if we could play for the court Lauren Dupree's testimony, and I would just note before you press play on this, John, that, Your Honor, we accidentally submitted Michael Dupree's testimony with our paperwork, even though we had correctly stated it was Lauren Dupree's. There's 2 individuals who were deposed in this case with the same last name, so I think we've either submitted an errata this morning or we're in the process of doing so. But we are going to show you that exact testimony that was cited in our brief from Lauren Dupree. It is in opposition. Go ahead.
Why'd you submit it this morning?
Do you recall determining that the Real Water Henderson facility started manufacturing Real Water in August or September of 2020?
It appeared that way.
Based off the water consumption records?
That's right.
You saw a noticeable jump in the water consumption for that facility in August and September of 2020?
That's right.
That's good. Good pause it there.
Did you also?
And Your Honor,
Why is that important?
that's important because what Southern Nevada Health District did was go back and look at the actual water consumption records to see when they actually started. So Mr. Kemp wants you to believe the September 30th, 2020 date. That's what's in the FDA Establishment Inspection Report. But when Southern Nevada Health District didn't believe that date, and they went back and actually checked and they pulled the actual water consumption records from the water department, they were able to determine that it actually was earlier and that this facility was actually operating in August of 2020. And if I could give you one.
But the only reason I asked that, how many days are in August? 30, right?
Yeah.
And, okay, and she testified August or September, based upon the water consumption records. We know, and it appears to me this is an uncontroverted fact, that the last home delivery date at the Wren residence was August 13th.
That is not an uncontroverted fact. We'll get to that in a bit.
Tell me why.
Why that's not uncontroverted?
Yeah.
Well, I think, Your Honor.
Either it's a fact or it's not a fact, right? When were the last home delivery dates for the Wren property?
So the first problem before I get there, Your Honor, is that Wren is not a confirmed, it is not confirmed that Wren is a probable case. So unfortunately, early in this case, we drafted authorizations for all of these plaintiffs, including the ones that are not in the case before Your Honor. So Your Honor has a case with one person who's a probable case, and then the other 6 individuals are not even probable or suspect cases identified by the Southern Nevada Health District. So what we did is we wanted to get to the bottom of it, and we gave plaintiffs' counsel authorizations that they were supposed to have their clients sign for, including Ren and all of these other individuals. They refused to do so. They only gave us it for these 7 individuals in the Gallagher case. So we were able to submit those to the Southern Nevada Health District, and we now have confirmed that from the Southern Nevada Health District, the only probable case in this case before Your Honor is Gallagher. So the Southern Nevada Health District has not confirmed anything else but for any other individuals. And so actually, Mr. Pepperman.
I understand that, but my point is this, I'm circling back to August 13th. That was the last home delivery, right?
So the problem with that is that it's not confirmed that Ren is the probable case that's referenced in the CDC's document. So, I mean.
What's the standard of proof as far as this case is concerned? I would anticipate they have expert testimony that ties it up.
They do not, and that's the other problem. So, what I just heard now is that they're not going to submit any expert testimony on causation, and apparently they're saying that this is for notice, and so it's not for the truth of the matter asserted, and that's absolutely incorrect. Obviously, they are submitting to the jury and asking the jury to infer, based off of all this hearsay evidence, and apparently 2 pages of Mr. Ren's medical records, that the jury can infer that, causation against all of these parties based off of these individuals who, Mr. Ren's a non-party. He's not in this case. We don't have any of his medical records. We haven't spoken to any of his doctors because they haven't given us the information. So we haven't been able to even investigate if this was caused by real water, or if it was caused by something completely different, alcohol abuse, anything. So, Your Honor, if I could.
Did you take Ren's deposition?
We have not. We've not been given an opportunity. So we don't have any medical records from him. He's not in this case, Your Honor. So that is our point on why this is hearsay. And, we're not even able to investigate to see if he's a probable case or not. Now, I get that based off the timing and what they're pointing to and whatnot, it's possible that maybe he is, but we have not been able to verify that. And we don't have any information. We haven't been able to depose anyone or have any sort of information about Mr. Wren. So, Your Honor, if I could indulge you also on the water consumption, and now Real Water actually just produced something recently that unfortunately wasn't in our brief, but I would like to show Your Honor a document that the electrical consumption for the Henderson facility that shows that actually throughout August, it was in operation according to the electricity, and actually was having more electrical output in August than it was in September when Mr. Kemp, says that the facility started operating. So, if Your Honor would allow me, I'd like to put that on the screen now. And John, could you?
This wasn't in the opposition. We didn't get a chance to reply to it.
Yeah, as I said, it was not in opposition, Your Honor. It was just produced by Real Water.
Is there a production problem? I'm asking you, sir.
Yeah, we've been receiving kind of rolling instructions. I mean, there's no problem from our standpoint, but I don't believe that this was available at the time of our opposition. I want to check that, but we certainly did not discover it until yesterday, actually.
But if it wasn't discovered until yesterday, should I consider it?
Well, I think if it wasn't produced, we didn't have the opportunity to discover it until yesterday. But I defer to Your Honor on that, and that's why I did give you the disclaimer on it.
I need to have the entire history as far as that's concerned before I make a decision. I'm always guarded in having it, but go ahead.
Your Honor,
Yes.
Your Honor, can we take it off the screen until that decision is made? If it was just produced yesterday, we had no opportunity to look at it as part of this briefing. That's not how this, I've never seen this court allow something that's never been produced before.
I mean, that's, in discussing the first motion, that's why I was making a distinction between when it's
I
produced,
get it.
right?
I think we all get it. But at least we have an admission here that this was not produced as a part of a briefing. And for it to be argued now is inappropriate.
Well, to be clear, Your Honor, I don't represent Real Water, so I mean, we're
I mean, ultimately, and I just want to be clear, I typically don't get records and documents that I have to consider as it pertains to the dispositive motion the day of the motion. I just want to say that, right?
And I completely understand that, Your Honor. I think that this actually goes to the fact that this is such a heavily disputed factual issue where we're literally weeding through hundreds of thousands of documents, finding information like this that prove that in fact this facility was operating in August. And so, we're happy to submit this to the court and, explain the facts on when we received this and whatnot, but we do think that it's
When you say
relevant.
when you received it, who did you receive it from? I'm trying to understand.
This is from defendant Real Water. They produced it. And they have made voluminous productions. So I think basically what they've been doing is,
When did they produce?
I need to go back and look at that. I certainly did not discover it until yesterday.
But I mean, when did they produce it? Sir, when was it produced?
Matthew Kaufmann on behalf of Real Water, if I can interject real quick, I think I can add some. We produced this within the last 2 weeks based on the basis.
Why wasn't it produced earlier?
We've been reviewing documents, we've produced over 260,000 pages to date at this point.
It seems to me though, that, you reviewed them, but they show, how long has this case been in?
He's still working on a new phone, Your Honor.
I'm trying to find out the exact date this was produced, Your Honor, because I don't think Real Water's made a significant production in the last couple of days since he's represented.
I think it was produced about a week and a half, 2 weeks ago in the last 16.1.
We'll find out exactly when.
But when, shouldn't it have been produced much earlier than that? Because this would be in your possession, custody, and or control, right?
No, Your Honor. Joan Odou on behalf of Real Water. The documents were scanned by Hollow, and as Hollow released them to us, we produced them. So this was not something that we delayed in production. There was just so many of them, and this has been the subject of numerous hearings and special master hearings. These particular documents, I believe, came through Hollow, and then they were produced. It's an overwhelming production. It's in excess of 260,000 documents and counting. And so there's been a rolling production of documents. As Hollow finishes scanning them, they are produced.
Again, Your Honor, you're familiar with the rule. Under 16.1, A1, you have your initial disclosures. Obviously, this wouldn't be a part of the initial unless they had it. Under A2, you have expert disclosures. And then under A2E, you have pre-trial disclosures. All of these disclosure requirements under 16.1 would have been not met by this document in the last 2 weeks. So, given that it has not been met, and given that we're just seeing this document for the first time in a briefing that even would not be allowed under a motion for reconsideration, you can't use it. It should be taken down, and we should be able to argue based upon the briefing before us and the exhibits attached to those things that we had leading up to the day. Not something new for the first time.
And what's your response to that, sir?
Your Honor, obviously, we are completely dependent on Real Water when we receive these documents, and what we're trying to do is just get to the truth of this issue. And the truth of the issue,
But I mean, it's more complex than just the truth of the issue. If that's the case, we just wouldn't have discovery. We show up at trial and we stacks of documents and so on, right?
well,
Because when was the discovery cut off in this case?
June 9th, Your Honor.
So, Your Honor, I mean, we would invite the ability to submit to Your Honor a declaration on this when we received it and be able to submit it to the court.
Well, what you would have to establish would be this to the court, would be substantial justification for the failure to produce a discovery, and they have to give an opportunity to respond and potentially discuss issues regarding prejudice and all that.
And Your Honor, at this late date, it goes beyond even just substantial justification. It's got to go excusable neglect at this point. I mean, he's way past his time.
I'm not, Mr. Parker, I'm not making an ultimate decision on that, but I mean, we'd have to go through the appropriate law and motion to do that.
That's correct.
It's like 6 minutes. But,
Your Honor, I completely,
sir, we can go ahead and pull that down, because I haven't had a chance to look at it either. And I try to follow everything, but one of the issues you talked about, and what impact does the validity case have on this? Because their position is we're not bringing it in for the purposes of quote, medical causation, but they're bringing the prior incident to show notice. And I understand this, sir, you don't have to explain medical causation to me, because I have two similar cases on medical causation where Mr. Parker, I was informed on both. You can go ahead.
yes, Your Honor, we think that case has a big impact on it. We don't think that they're submitting this just for notice. They are obviously trying to suggest to the jury and have the jury infer that this entire outbreak, was caused in a certain way based off of this red case where we don't have the information. So obviously, why notice has a lesser standard is because, basically, you're not gonna infer to the jury, you're not gonna have the jury infer that, there's certain causation based off of this inadmissible hearsay evidence. But that is what they're trying to do. So we do think it has a bit of impact. We think it's a misstatement to say that they're not submitting this for the truth of the matter asserted. Your Honor,
There's a lot you just brought in there between hearsay, truth of the matter asserted. You talked about causation. They're bringing it in for notice. That's a different issue.
well, if they're bringing it for notice, I mean, I think that would have to be in a very specific circumstance. There'd obviously have to be instructions and whatnot. And what they're suggesting to the court on how they're going to use it is not for notice. So I think that we would need further briefing on that. But Your Honor, if I could get back to the water consumption, which is before the court, and the other evidence to show that there is a factual dispute here, and including the timeline that Mr. Kemp went through. So it's undisputed based off Mr. Kemp's timeline. As in his reply, it's undisputed that Real Water took possession of that facility on August 11th, 2020. So even if we assume.
So when you say, okay, they took possession, but there's a difference between possession and operation, right?
Yes, there is.
I mean, that's a tremendous difference.
Yes.
So what are you trying to say, sir?
So obviously it's undisputed that they took possession before, even if we assume this Wren delivery date of August 13th, it's undisputed that they took delivery before. Now we have testimony in the case that one other thing Real Water would do is they would just take water jugs, fill them up, and deliver them without even going through the process. They would also take water jugs from one facility, store them at another facility, and then distribute them that way. So to say that we can't say that the court should make a ruling as a matter of law and basically take this from the jury and decide that this water did not come from that Henderson facility when it's undisputed that they had taken possession before that date is completely improper.
But when did production start?
That's a heavily disputed issue of fact in this case. So
What evidence do we have that production started on or before August 13th of the year in question?
we have water consumption records showing that throughout August, that they were consuming a significant amount of water compared to July.
Sir, you gotta be particular with it.
Yeah.
I gotta have specifics, because I'm looking at the dates.
Yeah, and so we have water consumption records that.
What did the water consumption records say regarding what was going on or before August 13th? And just as important too, do we have any testimony between, as it pertains to production dates, delivery, storage, all that? Because I would anticipate that plays a role too.
We do not. So, as Mr. Kemp pointed out, there are not dates on these 5-gallon jugs. So there's no way for them to say it did not go through Henderson. There are not dates that show, for instance, now I would tell Your Honor, we have testimony from multiple Real Water individuals, including the person that Mr. Kemp said makes the super bad batch, that's Casey Aiken. We submitted his testimony, that's Exhibit C to our opposition. And when Mr. Neale asked Casey Aiken what happened, like essentially why this outbreak happened, Mr. Aiken responded and he said, quote, I believe, well, I will state it like this. When we were in our original factory, plant, whatever, somebody took over that place, bought the property, so they had to move out quickly. We moved everything out of that plant and into 2 separate facilities, the one in Henderson and the one in Arizona. So by moving everything kind of on quick notice, but keeping up with demand of the water, we went right into production right away in Henderson. And right away, I wasn't in Arizona.
What does right away mean?
I agree, but there's no testimony here that, there's not evidence that prevents this from us showing that basically they got water from Henderson before August 13th.
What testimony would that be?
So here, we have Casey Aiken saying that they started production right away in Henderson. We have water consumption records.
But I mean, what water, we have, give me dates. And the reason why I bring that up, for example, and you've prepared discovery in this case, let me look at this. On August 18th, why was the eviction order rescinded? Because of a rent payment?
So Your Honor, I'd like to address that one too. So Blaine Jones, the main person, This is our testimony from Exhibit E to our opposition. This is the testimony of Lane Jones. The eviction notice is really irrelevant here. I mean, they were getting evicted, but the testimony all says from Lane Jones that he actually moved out the Dostal and Low machine. This is the big 5-gallon production machine that Mr. Kemp referred to as the Winnebago. He says here on Exhibit E, page 157, line 16 to 18, did you get the machine out of there before these started or after? He's referring to the eviction proceedings. He says before, but I don't specifically recall. Now, part of the problem Your Honor is running into, and so for some further context, plaintiffs didn't make this argument about Christopher Wren until probably the last month or so, 2 months. So we went through discovery, and this was never an issue because Christopher Wren is a non-party. There's no evidence here that he is the other probable case that Southern Nevada Health District is referring to. But in the last 2 months, when all these motions started being drafted, they came up with this theory, and in fact, they made this argument, if I remember correctly, for the first time at one of the expert depositions. So after fact discovery had already completed. So that's why Your Honor is not seeing specific references to August 13th and August 18th and whatnot in these deposition transcripts.
And is Mr. Wren a party in another case?
He is in another case, which we do not have any clients in that case, so we do not get any of that discovery. And plaintiffs have not produced or disclosed that evidence in this case. Your Honor, the other employee who was boots on the ground in that Henderson facility, who was actually the home and office delivery manager of that Henderson facility, was Anthony Brown. Anthony Brown testified that he got 25 to 30 complaints that were all connected back to the Henderson facility, and that he actually did his own root cause analysis, and they were all connected back to the Henderson facility. So, Your Honor, the actual real water individuals, including Mr. Aiken, including Mr. Brown, all believed that it was the Henderson facility. And I would just note, for Your Honor, that Mr. Kemp overstates our position about the Henderson facility. He misstates it. So we don't actually say that it's just Henderson specific. It's actually 5-gallon specific is our opinion. And that's actually confirmed by the Exhibit B in our opposition, which is the actual CDC publication that Mr. Kemp took you through. So in Exhibit B, he didn't show you, I don't believe, this sentence, but this is on the first page, the second right-hand column.
Is that 1617?
Yes, 1617, right-hand column of that page. The end of the second, or I guess it'd be third paragraph on that page, it says, all patients with probable cases consumed water from the 5-gallon size product before illness onset. So, Your Honor, all of the testimony in this case, from Southern Nevada Health District, here, from CDC, FDA, they've all found that all of the probable cases, 21 out of the 21 probable cases, consumed the 5-gallon product. There was not a single probable case that consumed only retail water of real water. So it misstates our position to say that it's only Henderson specific. Now, we do believe that there was some sort of issue with the breakdown of the machine, and when this eviction was happening, and essentially the transfer over of the machine to the Henderson facility, that is our position. We do believe that it happened sometime in that instance, and that's what our experts explain. But to say that our position is only Henderson specific misstates it. It's too narrow of a reading of it, and we don't say that. We actually, our position is that it's 5-gallon only. And Your Honor, as I said, the 21 out of 21 cases were all 5-gallon consumers. So even if that's Mr. Wren, that includes Mr. Wren.
Anything else?
Yes, so, Your Honor, Mr. Kemp talked about hydrazine, and he suggested to you that somehow, because this document you're looking at now doesn't identify hydrazine as the causative agent, that, they got some results for hydrazine after the fact, later in 2021, and, you should believe that essentially hydrazine is the cause. Well, we deposed the Southern Nevada Health District's person most knowledgeable about 2 to 3 months ago. She is the epidemiologist for the Southern Nevada Health District. She testified that even as of now, 2023, she doesn't know the cause of aging. So even after being shown hydrazine test results by Mr. Pepperman, she said that she wasn't aware of the cause of aging. There was no conclusion by her, and she wasn't aware of a conclusion by FDA or CDC currently as to the cause of the 5-gallon, or the real water issue. Now, of course, we would submit that it is a 5-gallon issue. We have expert testimony on that fact. So, Your Honor, to sum it up, we think that this is a heavily disputed issue. There's conflicting statements. I mean, even by Mr. Kemp's explanations alone, the September 30th, 2020 date that Mr. Joan said to one of the investigators at one point in time is not true. We have water consumption records showing that that is not true. I mean, there was extreme water consumption levels raised from July to August. So we know in and of itself that that statement to the investigators is not true. We have undisputed positions here between the parties that real water took possession by at least August 11th. So even if Mr. Kemp's position is true, that the Wren household was delivered a 5-gallon jug on August 13th, that very easily could have been routed or come from the Henderson facility. So, Your Honor, we don't believe that Your Honor should play jury on this highly disputed fact issue, and we don't think that there's any appropriate determination here to be made as a matter of law.
Thank you, sir.
Again, the trigger date is August 13th. Trigger date's
Well,
not-
we also filed a response. I'm gonna be real quick.
Go ahead.
You'll get your moment in the sun, I promise. Morning, Your Honor. Kaufmann, on behalf of Real Water. I'm just gonna be very quick. I don't have audio, visual, or the rhetorical skills of Mr. Kemp, but as raised by Mr. Hoffman, Mr. Wren is not a plaintiff in this case. Mr. Wren is plaintiff in another case, represented by Mr. Kemp's office. And they had a chance, if they wanted to make his illness an issue, they could have done so. I also think it's worth noting that Mr. Wren's son did not get sick in August. He did not get sick until November of 2020. We're not taking a position factually about the opening date of Henderson here. We believe the documents speak for themselves. The position is, but we believe that legally this is not the proper case to bring this motion should be brought in the Wren case, not the Gallagher case. And finally, plaintiff's reply refers to several notice cases, and I'm sure you probably know all these. Robinson versus GCC, which was a box crusher. Guinness involved a revolving door. Ryder versus Toby involved a meat slicer. Andrew versus Harley Davidson involved people burning themselves on a motorcycle. Ryan Gallagher versus Wet n Wild was about slip and falls. The one thing all these have in common is that all of these involve very obvious physical injury. If you get your hand caught in a box crusher, everyone knows where it came from. If you have liver injury, you don't necessarily know where it comes from. And while it's not in Mr. Wren's record, there are other issues in his record that could cause liver injury. So it's not necessarily a slam dunk as Plaintiff has described it.
You say there's other items in his medical records that could have caused liver injury. What do you mean by that?
I didn't want to get into this too much, and I apologize. Mr. Wren has a history of taking injectable testosterone and injectable steroids, both of which have been known to cause elevated liver problems and liver injury.
I mean, was there an alternative? Was there an independent alternative causation offered in that case?
No, because we have not disclosed experts in that case yet, Your Honor. No one has disclosed experts in that case. So we don't have any real causation aside from what plaintiff claims and the fact that he ate his wife's chicken salad, as stated in his medical records. So we don't have any expert testimony on Mr. Wren at this point. The other thing I would like to mention is, and as plaintiff mentioned, this is gonna come up later about the Burke article. They deposed the lead author of the Burke article, actually, Dr. Tamar, who was the first medical doctor listed on that article. And he stated very specifically that he could not say that real water was the causative agent for the people discussed in that article. So I just wanted to bring those points up to you, Your Honor, and I'm happy to answer any questions you may have.
None at this time, sir.
Thank you, Your Honor.
Your Honor, Scott Rasmussen, on behalf of Hanna, since we also filed an opposition to this case, we'll go ahead and submit on the record what we produced. Thank you.
Thank you, sir.
Your Honor, Woods versus Safeway requires that they produce facts in contravention of a motion or submission. They're not supposed to produce context, arguments based on facts. And so when you boil down the facts, you've got a trigger date of August 13th. That's the date of home delivery. That doesn't seem to be disputed. And we have their concession now that the move date could not have been before August 11th. And that's the date on the realtor where they took possession. Okay. So now their argument, this is really incredible. Their argument is that they moved the fill machine, moved the entire plant, started production, and made a home delivery on August 13th. That is the most ridiculous argument I've heard in a long time, Your Honor. They know that didn't happen, and the reason they know that this didn't happen is Mr. Neale asked Mr. Jones, after he moved the fill machine, how long would it take? Can I have that, Shane? This is his deposition testimony, Your Honor. We cited this in the reply. After you move the fill machine from Desert Inn to Henderson, how long before you get the plant up and running? A few weeks. Twice he told them this. Okay, they've got to hit 2 days, August 11th through August 13th. No way was this Henderson plant up and running by August 13th. You know, and they don't want to admit it because their experts say, oh, all the probable cases, you just heard them, all the probable cases came from Henderson. Well, there's no medical records produced on the other 20 probable cases, except for Ryerson, of course. So those other 19 cases, they want to rely on them. They want to have their experts look at them. We don't have medical records for those cases. I have some, they don't have any. And then with regards to the Wren medical records, they told you a direct lie, Your Honor. They said I haven't given them the medical records. Well, I Federal Expressed every medical record that's attached to this motion or reply 3 times. I sent it to him, I sent it to him, and I sent it to him. And I attached the Federal Express invoices to the reply. So not only did they have the medical records, but I Federal Expressed them. But out of abundance of caution, to prevent this kind of false argument to the court that I didn't give them the medical records, I took every single medical record in the Wren case, which is the first filed case, and I filed it in this Gallagher case on July 10th, 2 weeks ago. So now they stand up in open court and they tell you, oh, we don't have the Wren medical records. Just not true, Your Honor. The key date is August 13th. Now they start with this Dupree testimony. Oh, the water usage started in August or September. Okay, let's see what Dupree really said after they made the statement that they said to you. Shane, please. We got the September 30th date, Mr. Jones' statement. Again, this is the witness that he said creates an issue fact. Are those dates consistent with your review of the water usage records? Yes, I believe that the water consumption records would reflect that. So September 30th is consistent with the water records. All right? Now, let's take a look at this Nevada energy bill. Council started out by saying that they supplemented this. I still haven't seen the supplement, but maybe they did. That document, I verified, was produced on July 10th, 2 weeks ago, okay? No reason they couldn't have supplemented before now. But what does that really prove? Even if we were to consider an August billing from real water, all that proves that someone was running the air conditioning there in August, okay? Could equally be the realtor showing the property, they turn on the air. We don't know. I mean, and we don't know because they didn't take a deposition of anyone at Nevada Power, which they could have done if they wanted to. So that doesn't prove anything.
I want to make sure I'm clear on the consumption records. These aren't from the Henderson City Hall for water.
No, they're from, that's another good point, Your Honor. They're for the whole complex, okay? They're not just real water specific. These are from the industrial park that real water is in. And they're saying that the consumption went up in August in the whole industrial park.
But when you say consumption, I want to make sure.
Water consumption. Okay, water consumption. So rather than offer one single fact, they haven't offered any. And their own testimony that it takes 2 weeks to get the film machine set up, that kills the whole issue, Your Honor, because we're just asking for the August 13th date. I could have gone further and asked for the Ryerson date because she was before September 30th, 2 on her first hospitalization. I could have asked for that, but I didn't. And the only reason I'm asking for it is because they say this is the key issue in the case. And now counsel says to you, oh, Judge, Mr. Kemp's wrong. Our expert didn't say all the probable cases came from Henderson. Well, I've cited his testimony in another motion. We're going to get to that, Your Honor. But, you know, now they're trying to retool it. Now they're trying to save it. Now they're trying to say, okay, when we said all the probable cases, we meant all of them except that one. But that's why they said in this opposition that this is the key issue in the case, and it is the key issue. So we don't have any evidence. We have context. We have the contrary evidence that he solicited 2 weeks to move the film machine after August 11th. No way that got done by August 13th.
And when you talk about August 11th, I want to make sure the record's clear. That's the taking possession of the property day?
That is the date, okay, August 10th is the date of the eviction order.
Right.
They backed off that because of the subsequent eviction order that rescinded the first one.
Yeah.
So they're not arguing that as proof anymore. At least I don't think they are. So now they're arguing August 11th, they got the keys. How ridiculous of an argument is this? They got the keys on August 11th, and they moved this big film machine, got it all set up, started making water, and they were doing delivery in the next 2 days, okay? You know, there's no facts here. But I keep coming back to Mr. Jones's 2 weeks to set it up. No way that machine was set up. Under the best day, according to their facts, at 2 weeks to August 11th, you get to August 25th. And again, August 13th is the true day. So for that reason, Your Honor, this motion should be granted. And again, all we're asking is an undisputed fact that the water delivered to Christopher Wren on August 13th came from the Desert facility. Okay, and, you know, we don't have to prove that Mr. Wren's case was caused by acute liver injury. We don't have to prove that. None of the notice cases prove that. These are offered for notice, you know. The Neale case goes into that, a lot of detail. They have some nice reasoning. But that's what all the Nevada cases say. You know, we're not having mini trials for each one of those 16 repair orders. We're not bringing in doctors for each one of those 16 plaintiffs. We're offering the evidence for notice. And that's not even the issue, Your Honor. That's another motion to exclude that their argument is not a priority. I'm just saying that it is a fact that that water came from Desert Inn, and that is a fact, and that's all we're asking, of course, is true.
And last but not least, I just want to make sure the record's clear. The keys were obtained on August 11th?
August 11th.
Your Honor, there's an email from a realtor saying you took possession this morning that's dated August 11th.
Right.
There's a lease stated that begins August 8th. There's nothing about keys at all. We're the non-moving party. The date that production started is not established. We're entitled to every inference there could possibly be.
But it can't be based upon speculation and conjecture.
I'm not asking the court to speculate or engage in conjecture, Mr. Kemp is. We know that the 5-gallon fill machine was moved out before the eviction proceedings started on August 8th.
We don't know that at all, Your Honor.
But I mean, I keep coming back to, we know possession was obtained on August 11th.
We know that there's an email that says,
You know you're doing good, Your Honor, when a second attorney from the exact same law firm has to get up and take over the motion.
But go ahead. And Mr. Kemp, we don't need that, sir. We're professional in this department. We are. But go ahead and answer, sir, because I'm trying to figure out, I'm looking at it from a factual perspective.
yes, sir.
If we have, if the realtor said, you know what, possession, it's yours on August 11th, and then there was a delivery on August 13th.
Yes, sir.
Under those set of facts, how could the delivery, the product come from the Henderson location? Under that set of facts, how can that happen?
Your Honor, let me first say, I'm sorry for standing up and
No,
responding
that's
to court.
okay. No, you
And I'm
have
sorry to Mr. Hoffman,
to, you have
because
to
it is his
understand
argument.
this. That doesn't bother me at
Okay.
all. I'm just
I
trying
hope it doesn't bother my colleague.
No
I'm
offense.
just trying to drill down. And I don't care what the source is, and I think every lawyer in here has been in front of me 50 times. Mr. Robbins, how many times?
More than 50.
More than
John,
50.
do you have
Right, I mean,
Jones'
I'm just asking.
deposition testimony on moving? Your Honor, Mr. Jones, who's in charge of the move, says, I moved the 5-gallon fill machine out of DI prior to the eviction proceedings beginning. The inception, I think it might have been in the notes. That's August 8th. That's page 157, lines 16 through 19. Did you get the machine out of there before those proceedings started or after? Before, but I don't specifically recall when. It's out of one facility before the 8th of August. There's nothing, Your Honor, that says it couldn't have been in Henderson before the 11th. But even if we accept the realtor's email as gospel, the realtor to whom nobody has spoken, the hearsay email saying August 11th, the hearsay email that doesn't explain what she meant by took possession. Even if we assume that, there's 48 hours between that and the supposed delivery from another hearsay document from Real Water saying August 13th.
But we have testimony from the, I guess, the production gentleman from Real Water that says after the move, it's gonna take 2 weeks to get up and running.
He doesn't say after the move, Your Honor. He says it took me about 2 weeks to move that machine to get it up and running. We have no idea when the move started, except for his testimony that it started before August 8th. You can't, Your Honor, I understand that there's uncertainty here. And I'm not trying to tell the court that it should be certain. That's not the defendant's, the non-movant's burden. This is a motion for summary judgment from the plaintiff. The plaintiff has to demonstrate to you the date on which production started. He can't. There's no way to do that. The non-movants are entitled to every inference. You have to deny the motion if you don't know the date production started. And nobody knows the date the production started.
Well, but we do know this, okay, we'll assume the date of let's go back to August 8th. It takes 2 weeks to move and get up and running. That's from the production individual for Real Water, right?
But the move started before August 8th, according to Mr. Jones' testimony. He got the machine out of Desert Inn.
Your Honor, you want me to read you the actual testimony because I'm
You
sorry.
get the last one, Mr. Kemp. You
I'm
get-
sorry, Mr. Kemp, I didn't mean to interrupt you.
Well, it's an important issue. I want to make sure it's properly vetted.
Yes, sir. All we know from Mr. Jones is that he testified that he took the 5-gallon fill machine. And let me reiterate one point Mr. Hoffman made very well. What's undisputed is that everybody who got sick, according to the public health authorities, is a 5-gallon customer. Period. And I hope that puts this motion in some kind of context. It's not a question of Desert Inn versus Henderson. It's a question of the D&L 5-gallon fill machine and when the problem started. And there is absolutely no doubt that they started around August. That's why we have the August 1 case definition standard from the CDC and FDA. We know that there's an eviction proceeding that's initiated on August 8th. No later than that, it might have been earlier.
It was actually August 10th, but go ahead.
I think there's an order of eviction on August 10th, but the filing is made on August 8th. I could be mistaken.
I think the order would control, not the file.
I'm not, remember, Your Honor, they weren't kicked out. The only reason the eviction's at all relevant is because Mr. Jones testified that he moved the D&L 5-gallon fill machine out of Desert Inn prior to those proceedings. That's all we know. You can't decide as a matter of law, Your Honor, when production started. And I say that respectfully, but that's what you're being asked to do here. And you don't have an evidentiary record on which to do it. Certainly not an undisputed one. And certainly not one in light of the fact that the non-movements get every inference of every possible fact.
You done? You done?
No, and this, sir, if you're done, that's fine.
Thank you.
Your Honor, this is what Mr. Jones really said. Let me read the whole question because counsel's tried to spin it 3 different ways. Question: do you recall there were eviction proceedings from the Desert Inn facility? Correct. Answer: as far as I can remember. Question: did you get the machine out of there before those started or after? Answer: before, but, and this is what he keeps leaving out, but I don't specifically recall. Okay, that is the testimony he wants to hang on. Later in the deposition, he discussed when he actually got the machine done, and he said it was a couple of weeks before he went on his hunting trip in October. Question: and am I correct that the machine had relatively initially started back up again before you took your hunting trip? Answer: yes. So that moves it 4 weeks further, okay? But the bottom line here is, you know, we keep moving these dates. August 11th, August 10th, August 8th now. Doesn't matter. Let's use August 8th. Can we have Mr. Jones' testimony one more time, Shane? August 8th. Let's use August 8th. He says, not that one, the 2 weeks. He says it takes 2 weeks, twice. And this is him asking the question. It was at least a few weeks, maybe more. A few weeks, maybe a little more. So let's take August 8th. Add 2 weeks to that, we're at August 22nd. We're 9 days after the grand delivery. What they're contending is impossible, Your Honor. And that's why it's a very simple issue. You know, the reason they're fighting the obvious, you know, as I would say, squirming like a worm on a hook, is they know how important this is. This is what they call the key issue in the case, because they've had all their experts come in and say, oh, it's all Henderson, all the problems Henderson, all the probable cases came from Henderson. Okay, like I said earlier, they're going to retool and revamp that and try to get these experts to give revised opinions. But the bottom line is there is no fact you dispute here. Even if it's August 8th, and it's not, they didn't move that production machine to August 8th. They know that because they were still in production. They were doing production in Desert Inn on August 29th. They know that August 8th date's ridiculous. But let's assume it's August 8th. A few weeks, maybe a little more. That's after August 13th, Your Honor, and that's why the motion should be granted.
Okay. And I have one last point. Do we have copies of the deposition transcript
Of whom?
of the production individual?
Yeah, that's Mr. Jones, Your Honor.
Mr. Jones.
Yeah, we can get you a copy of that transcript.
Do you have it with you by chance?
I think Eric's going to try to find that out. There's actually 2 depositions of Mr. Jones.
Said he does not.
One is a long deposition where he's the PMK. I'm not sure which one.
I just want the facts. Or
Yeah.
I just want his opinion regarding the,
You want those 2 pages from a few weeks, a little more?
if there's anything else germane to that issue. I don't want to just limit it. I want the facts.
May I show the court one more fact from that same deposition, Your Honor?
And you can, sir.
Exhibit E, please, Mr. Stevens. Second to last page.
Your Honor, this is so improper. Go ahead.
This is the same Mr. Jones testifying about the same move with the same equipment. And you've seen the testimony at lines 16 through 18. I moved the fill machine out before the eviction proceedings, but I want to call the court's attention to the next question and answer. Line 19 through 22. And then it went to Desert Inn, it went to Henderson. And how quickly did you put it back in service? It took a few days. It started before August 8th, and it took a few days. And they had the building, and the delivery was August 13th. The court can't possibly decide this. It's impossible as a matter of law. This is the PMK for real water. The person in charge of the move, the executive vice president, chief of
Is
operations.
this the same, Mr. Jones?
Same Mr. Jones. It is completely unclear when the move started.
When I take a look at his answer, it took a couple weeks. The same thing he said twice before, okay? 3 times he said it now.
Okay.
Thank you.
And it's lunchtime, right? Yes. Yeah, my staff, they want lunch, so we have to take lunch, right? Can we get that to me shortly?
Where, Mr. Pepperman?
I don't know if you would call, if you could get copies of the deposition transcript to the court.
I just want to make sure the record's clear.
Yeah.
All right, let's go to lunch.
All right. What's the return time?
Um,
Do we have an hour and a half? I hate to ask, but I have one thing I need to take care of during the lunch break.
Yes, we can do that, Mr.
What
Clark.
time?
1:45?
1:45?
Okay, that's fine.
That's okay, Joe?
Yes.
Okay, thank you.
Please be seated.
All right, let's go ahead and set forth our appearances.
You're gonna look into planning?
Sorry, Eric Pepperman. Definitely, Teddy Parker on behalf of the company.
Jim Neale on behalf of UNFW, along with Joan Anderson, Nick Hoffman, and David Spurlock.
Joel Odou and Nick Kaufmann on behalf of the real water entities from Wood Smith.
Rob Robinson from Milwaukee. Scott Rasmussen from, where am I from? We're just coming with Brittany Lance.
Jim Kavanaugh for third-party defendant, Real Water Tennessee, LLC.
All right, does that cover all appearances? I think so. Before we get started, from a planning perspective, I would anticipate we're going to be continuing with motions next week, right?
Seems like it.
Because what we're going to do, hopefully next week, we're going to move into Judge Johnson's courtroom, have more rooms.
Thank you.
Just to let you know that, just a little more.
When you say Judge Johnson, you mean Susan Johnson, correct?
Yes.
Thank you.
Yes. And I'm looking here, for example, on the 31st, it looks like we could start on at 10:30 in the courtroom, but we'll get a schedule for you done between now and then, as far as times and all that.
Here on that note, I don't know if you're anticipating this Thursday. I've already talked to the other council about this, but I do have a conflict Thursday morning. If we can just move around that, and that's only until, just in the morning.
I mean, there'll be conflicts, but that's why we're starting early.
I understand, it's not for that, it's for something else.
No, but I mean, just in general, I mean, for example, I have a conflict just arose, and I have to leave at 3:30.
Okay, I get
Mr.
it,
Parker had a conflict.
I understand. Thank you very much. That's all.
And we'll take care of your conflict too.
Thank you, Your Honor.
You're welcome, sir. All right, so I guess next up is that motion for summary judgment number 2.
Before that, Your Honor, you requested the transcripts for Blaine Jones' deposition, which we put together.
Okay.
I already had opposing counsel review.
Okay, you
If I can confirm. I wasn't clear if you wanted both the depositions as 30B6 and his capacity, so I included both, just in case.
Thank you, sir. All right, let's go to number 2.
Good afternoon, Your Honor.
Yes, sir.
This is I believe it's a pretty simple motion. Let's address the easy part of it. The motion is simply to establish that all of the medical expenses related to all the plaintiffs' care and treatment regarding their liver injury is reasonable, necessary, and customary in terms of charges. I think our reply reflects that we are in agreement, or at least accepting of Jim Neale's position. I found one mistake in the math, and I wanted to correct that on the record. I believe you're looking at the math as a $10 difference between what's in our reply brief and what my math determined after going through the charges again. So for purposes of addressing Mr. Neale's clients, which is UNFW, oppositions to Belsky's medical expenses is a reduction of $544, which leaves a remaining total of $43,718.27. I think that's reflected in the reply. The mistake, I think, was made in the Haley reduction, and based upon my math, the reduction is $4,334, reducing the total original amount of $37,681 for a remaining total of $33,347. So I think only a $10 difference in my math.
I'll get your word, sir.
All right. So I think that takes care. I think that takes care of UNFW's opposition to our motion. And I was really surprised that there was any opposition, other than, of course, I'm not going to go back and forth over Mr. Neale's point, because I think it's not worth arguing about. But I didn't expect to see any more of an opposition to that. But Hanna did raise an opposition, Your Honor, and I will be brief in this regard. Under Rule 16.A2, if Hanna has an expert that it intends to introduce to contest the reasonableness or the necessity of the medical care and treatment or the customary charges, then it was required pursuant to 16.1A2 to identify an expert to do so. At this point, they've not identified any experts contesting any of the bills for any of the plaintiffs in this case. We've identified all of the treating physicians. I don't see the necessity of parading each one of them in here to simply say that their bills are correct and that they didn't overcharge someone. And I'm assuming that's what Mr. Rasmussen would be thinking if he believes that any of these doctors would come in and say that these medical bills that all discussed an acute liver injury was something other than that, or that they would come in and say that the care and treatment wasn't necessary, or that their bills were inflated in some way. So unless Mr. Rasmussen can give us some information that perhaps we overlooked in the form of a 16.1 expert disclosure, I really don't see the validity in his opposition.
All right, thank you, sir.
Your Honor, I'll just be very brief. Our opposition really had to do with certain things that were done that we asked the actual plaintiff, did you actually do that? Did that actually occur? Those sort of things. Melissa, that sort of testimony. It's going to be completely fact-based, but limited to, do you remember, did this happen? Obviously with certain witnesses, they may not remember, they do not recall. We understand that, but that was it, because there have been so few times when that has happened and someone says, no, that didn't happen. No, I don't remember that at all. That sort of stuff. It's not really required for us to bring an expert forward to do that. It's a question of that. Whether or not they remember even receiving the treatment that they talked about in their accumulation of the various amounts of medical expenses that they are suggesting that they have had over the time that they've been treated. That's all I have, Your Honor. Thank you.
Thank you.
Your Honor, our Rule 16.1 is not unique in this respect. If there's an objection to the authenticity, if there's an objection in any way to the documents being presented at the time of the 16.1 disclosure, you're obligated to actually say that and raise it as an objection to a 16.1 disclosure. That was not done by Mr. Rasmussen's firm. I understand his comments today. They're not really borne out in his written opposition. He raised a name of a Dr. Selznick, who was never identified in this case. But again, his comments just given, which are not reflected in his moving, in his opposing papers, aren't in tune with our 16.1 obligations. And again, we mentioned the FCH1 LLC versus Rodriguez case is the 2014 Nevada Supreme Court case. If you're going to question those portions of the medical care and treatment, you'd have to do it with a physician. And he's not contested up till now, and we're on the eve of trial, the reasonableness of the medical bills, the necessity of the medical care and treatment, or the customary charges of the bills. So I don't think that he can do so now.
And I just want to make sure where we're going on that. When you say reasonableness and customary, and when you say necessity, what do you mean by that?
So, Your Honor, you're familiar with the standard here. Typically, we ask that a medical physician comes in and testifies that the medical care was necessary and reasonable. Now, I looked at our brief. The original brief actually says, and this is, I'm sure, it's a typo. It actually says, Your Honor, the reasonably and customer based. I'm sure that was just a mistake. But certainly, the court, having done many trials, is familiar with the language where a physician comes in on plaintiff's side and will testify to the nature of the bills if it's contested by the defendant. Here, there's been not a single defendant that's contested the medical bills of treatment. There's been no experts designated that has provided an opinion that any of the bills were unnecessary, were not reasonable, and not customary in terms of charges. So the reasonableness of it, they had acute liver injury. Most of them were taken, all of them were taken to hospitals. They were treated in the hospitals. The diagnosis references acute liver injury, and they received care and treatment for that, and the bills we believe to be customary. And there's been no experts offered by the defendants questioning any of those things. Thank you, Your Honor.
And in light of that, what I'm going to do, Mr. Park, I'll go ahead and grant the motion.
Thank you, Your Honor.
So what do we leave off now? That'll be number 2. Yeah, so we move on to number 3, right?
Yes, Your Honor. And that's also not the one I intend to argue as well, Your Honor. Your Honor, this one, again, I don't believe there should be much issue to it, but there was a fairly robust opposition filed by UNFW. And this motion is that UNFW supplied the Whole Foods the real water bottles allegedly consumed by Haley and Belsky. Where the opposition seems to suggest that there were perhaps other suppliers or distributors of real water retail bottles to Whole Foods. There's been no contracts identified by any other distributors, any other suppliers, and it's certainly not identified in the opposition filed by UNFW. What we have instead are responses to requests for admissions, request number 1, request number 6, and request number 8. And I'm not going through each one of these, regurgitating what's there, Your Honor, because it's fairly well briefed. The actual request is identified in the motion along with the responses. In short form, UNFW admitted that it distributed 1,044 bottles to Whole Foods in 2018, 580 bottles in 2019, and 596 bottles in 2020. In response to request number 6, UNFW admits to picking up real water retail bottles from Real Water's Desert Inn location prior to August of 2020. And then a request for admission number 8, UNFW admits that after August 20, it picked up and delivered retail bottles from Real Water's Mesa facility. I don't believe that I think the opposition went beyond the actual motion, attempting to argue that we were saying that the exact bottles delivered had a certain level of hydrazine within it, or the amount of hydrazine per bottle. This motion is not geared to establishing those facts, Your Honor. It's simply indicating that, to our knowledge, based upon the discovery that's been done to date, there's no other distributor or supplier of retail water bottles to Whole Foods in Reno or Haley would have purchased and consumed water bottles, or in Las Vegas where Mr. Belsky would have. Your Honor, we cite a considerable amount of case law in support of our position. And again, without UNF providing facts or documents, I would say, indicating that there's another supplier of retail real water bottles to both Reno and Las Vegas Whole Foods locations, I believe this motion should be granted as well.
Thank you, sir.
Thank you, Your Honor.
Ma'am.
Good afternoon, Your Honor. Joan Anderson from United Natural Foods. Your Honor, it's plaintiff's burden to show that United Natural Foods distributed the bottles of water consumed by the plaintiffs, Haley and Belsky, who claimed injury from those retail bottles. There's no direct evidence of that, so what plaintiffs are trying to do is show that UNFI was Whole Foods' only distributor. And so in their opening papers, plaintiffs cited 2 written discovery responses, and Mr. Parker just referred to them. The first was UNFI's response to request for admission number 1, which asked UNFI to admit that all of the real water product that Whole Foods sold at Whole Foods in Reno was distributed to Whole Foods by United Natural Foods. And United Natural Foods concluded its response to that request for admission saying that defendant, United Natural Foods, lacks sufficient information to admit or deny whether it was the only distributor of any real water product to the Reno store. So that does not establish that United Natural Foods was the only supplier to Reno. Then plaintiffs cite request for admission number 6, and this is Plaintiffs Exhibit 1, page 6. And all this asked was whether United Natural Foods actually distributed water from the Desert Inn facility. And United Natural Foods says, yes, we did. We picked up sealed packages of retail-sized bottles of real water from the Desert Inn facility for distribution nationwide to entities. It says nothing about Whole Foods or the Whole Foods Reno store. So in opposition, United Natural Foods pointed out that plaintiffs hadn't met their burden of showing an absence of a material issue of fact. And then on reply, plaintiffs cite additional information. They cite, for example, the deposition testimony of Robert Brown. Now this is the recall manager at Whole Foods who plaintiffs deposed in his personal capacity in this case. And Mr. Stevens, can you put up his testimony? So plaintiffs in their reply claim that Mr. Brown answered yes when asked whether the distribution relationship between UNFI and Whole Foods was exclusive. But they omit the second part of his answer. The yeah quoted by plaintiffs appears to be either an acknowledgement of the question or perhaps my objection, but then he goes on to say, we do have partnerships with other distributors. So this is not an exclusive relationship. Plaintiffs also quote Ray White, who's in charge of recalls at UNFI, also deposed in his personal capacity, but he was not asked if UNFI was the exclusive distributor of water to Whole Foods, and his answer, which is quoted in plaintiff's reply, specifically says he's speculating as to how one would know if the water was distributed by Whole Foods. Your Honor, I would submit that none of this shows the absence of a material issue of fact, and summary judgment should be denied.
Okay, thank you, ma'am.
Your Honor, I'd like to start off where counsel started. I think the words were, UNF cannot admit or deny that it was the sole distributor of real water bottles for Whole Foods. I think that's what she said. Again, if she cannot admit or deny, I'm guess that means she's not provided an affidavit, a deposition, an interrogatory response that's required under Rule 56 to defeat a motion for summary judgment. That's what the standard is in our rule, and that's what Wood safely says. And that's what has not been done here, either in argument or in the opposing papers. What we do have instead is a contract that was identified, UNF, the last three digits is 219, where it indicates that UNF is the primary distributor for Whole Foods. Now, if there was a defense, and Your Honor is very familiar with this and how the rule is handled, if there was a defense to UNF being the primary provider or distributor, then perhaps UNF should have provided a copy of the contract between this partnership or partners that they may have in the distribution stream, or any other document, since UNF's counsel also represents Whole Foods. So they would have access to those contracts. So if there were other contracts, Your Honor, they should have been provided in discovery, and they should have been identified and attached as an exhibit to the opposition. But they left this court with nothing of substance, nothing required by the rule to defend the motion for summary judgment. And I believe the language that counsel was referring to in terms of Mr. Brown's statement is that they were the exclusive distributor for Whole Foods except for perishables like meats and produce. I think that's what the testimony was regarding. So, Your Honor, we're not speaking here of meats, and we're not speaking here of produce. We're talking real water retail bottles. And there's not a single document identified in opposition to the motion for summary judgment saying that there was any other distributor or provider of real water bottles to the Whole Food stores where Mr. Haley and Mr. Belsky purchased real water retail bottles. And without an affidavit, which we don't have, from any employee saying otherwise, without any deposition testimony identifying any other distributors, which we do not have, and discovery being closed, John, UNFW leaves you with no other choice but to grant the motion for summary judgment, given their failure to comply with Rule 56, John.
And here's my question, I just want to make sure the record's clear. There's no issue regarding UNFW and the fact that they were a distributor to the Whole Foods retail outlet at issue, right?
No, Your Honor, not to my knowledge.
There's no issue that UNF distributed to the retail establishment, but UNF does not know if it's the only distributor. They're not privy to that information.
Your Honor, those comments so resemble what the Supreme Court said is not allowed as a defense to a motion for summary judgment. Speculation, unfortunately, does not shift the scales. Not
And there's
knowing,
been no other contracts produced
not a one, Your Honor.
from Whole Foods, any
Whole Foods
contracts?
isn't a party to this case.
Counsel represents Whole Foods as well, and made point of that earlier today when discussing Ms. Sarah Sandstrom. You take the good with the bad. And in this case, Your Honor, Rule 56 is clear. The only other point I would raise, Your Honor, under 16.1, the initial disclosures, they knew this would be a defense to their claims. It should have been produced in initial disclosures, Your Honor.
And I just want to make sure there's no evidence whatsoever that there were other distributors for Whole Foods at the store in question.
Well, that wasn't asked in any of the depositions. It wasn't requested. We were representing United Natural Foods in this case. I don't know what we would produce.
Here's my question, it goes to, it says this is the answer to the request for admission number 1. I'm looking at the final response. Defendant lacks, I will say, quote, defendant lacks sufficient information to admit or deny whether it was the only distributor of any real water product to this retail location. in any of these years, period, close quote.
Correct.
Anything else?
The only thing I would say, Your Honor, and I think this goes swimmingly with your last comment. If we were in trial and Whole Foods tried to suggest there was some other distributor, they didn't identify him in the 16.1. They didn't identify a company, a name, or a document. So the time has come and gone, and certainly it was focused when it came to this motion for summary judgment. And there's nothing that UNFW has attached to this opposition to support the arguments of counsel.
And how long has this litigation been going on now? If there were other distributors,
2.5 years, John.
if there were other distributors, would they have been named as parties to this case?
Same thing I said, John.
But go ahead, ma'am, I just want to make sure I'm.
No, Your Honor, but the entity that would have provided that is Whole Foods, they're not a defendant. I don't know, if they didn't supply 16.1s in connection with the Reno store. This is the only individual who is alleging purchases at the Reno store.
And Your Honor, if that was the case, they could have subpoenaed the record, they could have taken a deposition. If that was a defense, they're obligated to do their part in discovery. It wasn't done. And in fact, they stand now on the admissions, the request for admissions, that they have no information, no knowledge, and as a result, they can't oppose this motion for summary judgment.
No, it's not a defense, it's an element of, that they have to prove. It's not our burden.
I mean, I'm looking at it through this lens, there's been 2.5 years of litigation in this case. UNFW admits that it was a distributor
Correct.
of this product, right?
It was one distributor distributed nationwide, correct?
And then they also say, we know of no other distributor of any real water product to this retail location in any of these years.
No, that information would be with Whole Foods.
Okay,
How would UNFI know that?
they could subpoena, do a 30B6.
It's not our burden.
But ultimately, if you're gonna use it as an affirmative defense, it's gonna be your burden.
One horse, one rider, Mr. Neale.
I mean, really, if you wanna step and say, if you're gonna say somebody else did
One
it,
horse, one rider.
you have to come up with evidence that somebody else did it.
We're not saying that. We don't have to say that. It's not our burden. It's an element.
Right.
But they've proven that you've admitted you were a distributor.
But
So
that,
what other element would they have to prove?
that we distributed the bottles that were purchased by Mr. Healy. We don't even know when that was exactly. It would be impossible for us to provide that information.
Well, if you're the distributor for that specific
We're not
store.
the distributor, we're a distributor for Whole Foods. Whole Foods.
I'm not talking about nationwide, I'm talking about the store in general, because here you said, let me see here. Let me make sure I get this right. It says UNFW admits that its records show that it distributed retail-sized bottles of real water to the Whole Food stores at 6139 South Virginia Street, Reno, Nevada, in certain quantities, I guess 1,044 total bottles in all of 2018, 580 bottles in 2019, and 496 bottles in 2020, right?
That is correct, but whether that Whole Foods store got other bottles from other sources.
But you can't argue that unless you have some evidence of that. You can't just stand up and say, look, well, they could have got it from someplace else. They've met their burden there as far as the store is concerned.
That all we're doing on summary judgment is say that they didn't meet their burden of showing that there's no dispute of fact.
But there's no dispute of fact, if I'm reading this, that 1,044 bottles were sold and are distributed in 2018, right? Is that a factual dispute?
No, Your Honor. The fact that we distributed that water to that store is not in dispute.
Right. Okay.
That,
So they've met their burden as far as that quantity of water being distributed to that store, correct?
That's not the subject of the motion, but yes, they have demonstrated that we distributed water to that store.
Right.
Their motion is very different than that, as you know from having read it. Their motion is that we distributed the water that Mr. Haley consumed and that Mr. Belsky consumed, and that injured them. That's an element of their claim that they have the burden of production and persuasion, that they have to produce evidence of.
Well, you know, when there's two types of evidence, there's circumstantial evidence, right? And that's what this is, circumstantial evidence. And so if you're taking a position that someone else just, come on, listen, we have to be,
Intellectually honest here.
I mean, really, it's, if you're gonna say that there's another party responsible for the distribution of water in this case, you gotta tee them up.
We're not saying that. All we're
Okay, then
saying,
what are you saying then?
we're saying the court is obligated to deny the motion for summary judgment because the plaintiffs haven't produced evidence establishing that fact.
Well, there's an admission,
There's an admission that we distributed some water.
okay, in specific quantities, right?
Yes, sir. Yes, sir.
And there's no direct and/or circumstantial evidence that's been presented in this case, in this motion, that there were other distributors that were distributing water to the store during the time period in question, right?
You saw in Mr. Brown's testimony that there were other distributors for Whole Foods.
Yeah, but I'm talking about the water. We have an admission that your client,
Your Honor, if the court's satisfied that the plaintiffs have met their burden, all we need to do is rule and move on.
I understand that, but I want to make sure that I want to make sure I understand what the facts are.
You're not missing anything, Your Honor. We have Whole Foods saying that we have multiple distributors. We have us saying that we're one of the distributors. If you think that's sufficient to rule on summary judgment and the plaintiffs have met their burden,
Well, actually, it's a little bit more specific than that because there's a total number of bottles that were distributed for certain time periods.
yes, we gave them all the data we had from the Whole Foods data. Yeah, that's right.
Okay, I just want to make sure I'm missing.
You're not missing anything, Your Honor, except for the fact that the plaintiffs haven't produced evidence to satisfy a prima facie element of their case.
And what evidence would that be? What other evidence other than admissions that you saw that the bottles at question were distributed to the store?
It would be a question of a Whole Foods witness that said, did anybody else deliver water to that store? It would be a question of the other distributors in this litigation, did you ever deliver to Whole Foods? It would have been, there are any number of ways that the plaintiffs could have satisfied it, with the subpoena to the non-party, with requests for admission, with a 30B6, but it's their burden, Your Honor. And we're not going to stand up at trial and say that something happened that didn't happen. But at the same time, you don't relieve yourself of a burden by coming into court and saying, well, the defendant hasn't disproven my theory. Summary judgment, again, requires the plaintiff to produce evidence showing the absence of any material fact. We've shown you a deposition transcript from Whole Foods saying there are other distributors.
Your Honor, may I?
No.
Oh, I didn't know if he was done. I thought he was done as he was about to sit down. If you have,
I think the court understands the evidence and the court understands our position. And we'll abide by whatever the ruling of the court is.
initially, you know, I didn't want the two horses, two riders thing, but if this helps clear anything up, Your Honor, then I'm fine with Mr. Neale, giving his 2 cents. What I think Mr. Neale and his colleague failed to understand is something that the court has already said, I thought very pointedly. If you're going to defend a matter using a certain defense, pursuant to our rule 56, it says you have to bring competent evidence in support of that defense. Our motion is a sword and a shield. What has happened here is UNFW has not done anything over 2.5 years to prove that there's any other distributors. We've proven through requests for admissions, through written discovery, that they were a distributor. The shift in the responsibility to now support your defense, unfortunately, was not picked up by UNFW, and they did nothing to support their defense that they're trying to argue now, Your Honor. Rule 56 says the defending party has to provide proof by affidavits, interrogatory, deposition testimony. The deposition testimony they're speaking of doesn't identify another distributor. It doesn't indicate a name. It doesn't say that 10 bottles were distributed by or supplied by company ABC. UNF's current counsel represents Whole Foods. If there was another contract, the same way they produced the contract they had with Whole Foods, they should have produced those contracts. They have not defended or provided information, competent information, in support of their own defense. And now they're asking the court to ignore their admissions, ignore that there's no other evidence in this case suggesting another supplier or distributor, and to go on the gossamer threads of there could be someone else out there. We just don't know because although we represent Whole Foods, we didn't ask them for any other contracts. We decided not to take their 30B6 witness deposition. Maybe the plaintiff should have. The plaintiff is not charged with finding a way to help them defend their client's rights. And that's why at the end of discovery, we have dispositive motions, and there's no discovery that supports their defense to this motion.
After a review and consideration of the requests, the responses and answers to the request for admissions in this case, and in light of, I guess, the entire evidentiary background, I'm going to grant the motion, because if there were other distributors involved in this case, I would anticipate there would be a third-party claim for indemnity, contribution, those types of things. They haven't been done. There's an admission that this supplier was a distributor of, and they're actually specific as to the number of bottles. And to me, I don't see how you can defend a case when they've met their burden. If you're going to tee up someone else and say, look, it could be another distributor involved in this case, they could have been identified very easily. And so I don't see where there's a factual issue on this one at all. I'm going to grant the motion. So let's go on to the next one, number 5. Four.
Oh, and Your Honor, just as an administrative matter, I think in connection with this motion for summary judgment, we filed a motion to redact or seal Exhibit 2 to the motion, which was I believe that's the contract that we provided in support of our motion, which is a confidential document. So we'd ask in connection with the motion, you also grant the motion to seal.
Any objection?
No, but just for clarification, I think it was actually sales data and not the contract.
I apologize. Whatever the confidential exhibit, whatever the document marks
Any objection?
No.
Right. Okay, Mr. Kemp, where are we now?
We're on motion for summary judgment number 4, Your Honor. And to begin, this motion is just directed at Milwaukee. It's not directed at Hanna. It's not directed at Milwaukee. And it's not directed at UNFI. And the reason I say that is because everybody seems to be violently opposing this motion. So this motion is based upon the testimony of the real water epidemiologist. As the court's aware, this is an outright case. People that typically investigated are epidemiologists. In this case, we have an epidemiologist witness. Real Water has an epidemiologist witness. That's it. Those are the 2 epidemiology witnesses in the case. Hanna didn't hire one. Milwaukee didn't hire one. And UNF did not hire one. So their epidemiology opinion is given to us by Dr. Goldsmith. And before I get to our argument, I want to show you the 3 sections of testimony that we're relying upon. Shane, can I have the first one, please? Okay, could we blow that up a little bit? No, I think that's Mr. Jones. This is Goldsmith, from the reply on motion for summary judgment court. Okay, there we go, bottom. And there's no dispute that Dr. Goldsmith is qualified. Back when I took his deposition, I spent the first 20 minutes laying the foundation myself. And again, he's real water's epidemiologist. I didn't know this guy. So, this is his opinion. Hydrazine was the cause of this outbreak. And again, hydrazine is the rocket fuel that's associated with, there's a lot of studies that it causes acute liver injury. No one disputes that. So, here's his opinion. They're epidemiologists that hydrazine was the cause. Unless there's evidence that's been detected or evaluated by competent water source, research stories, I'm going to have to say hydrazine does appear to be the source of the outbreak, the acute liver outbreak. Now, he uses the term outbreak there, and the defendant sees on that in their opposition, but let's take a look at the other two segments of testimony, Shane. Okay. This, we're talking about, the top part. I asked him if he's given the opinion that hydrazine was the cause of the outbreak to a reasonable degree of epidemiological certainty. He says, yes, he's given this opinion to a reasonable degree of epidemiological certainty. And again, this is the real water epidemiologist. This is my guy. Next one, Shane. So for some reason, that someday I'll know the answer to, but I don't know now. For some reason, defendant UNF did testing on their own bottles. And so what they did is they took some of the retail bottles that were then embargoed in the Riverside warehouse after litigation. They can't sell them because they're under recall. They can't dispose of them because Special Master Hale entered an order on that point. So they were just sitting there in the warehouse in, I think it's Riverside. I might be getting the California town wrong. But so they took, and they had to give us notice of this. So they gave us notice that they were doing hydrazine testing on their own bottles. And hydrazine testing isn't the easiest thing in the world to do. You can't just, drop a pill in and see if something turns blue. You have to send it to a sophisticated lab. So in this case, they sent 7 of their own retail bottles to a lab called Eurofins in Indiana. And Eurofins actually developed the hydrazine test that's currently used by the EPA. So anyway, Eurofins tested the bottles, and they found that 5 of the bottles had hydrazine in them above the reporting limit that Eurofins was using. The 6th bottle was actually above the reporting limit, but they had a fudge factor, so they put it under it. So they reported 5 of the 7 retail bottles had hydrazine in it above their reporting limit. But the guy, when I took his deposition, said that there's objective evidence in the 6th bottle, and even the 7th bottle, they couldn't preclude that there was hydrazine in there because on the graphs in the back, it shows hydrazine matching up in 2 different places where it should. So anyway, I'm trying to explain what he's talking about here. So after he gave his initial opinion in the case that hydrazine was the cause of the outbreak, then he got this retail bottle testing from UNF, and he sees that on the retail bottles, remember their big theory is that, it's just these 5 gallons, it's not the retail bottles. Their own testing on the retail bottles shows that they have hydrazine. So that's the context of his testimony where he says, this is the smoking gun. Because the FDA, he refers to it there, they found hydrazine in the concentrate, 3 different samples. And I showed you that earlier, Your Honor, the FDA testing that came out in October of 2021. So in addition to that, he's got the FDA testing on the concentrate. Now he has the retail bottle testing. And so he's going, this is the smoking gun. This proves that this is a company-wide problem because, again, the retail bottles are not made in Henderson. Only the 5-gallon jugs are made in Henderson. So the fact we find hydrazine in the concentrate and hydrazine in the retail bottles, which aren't made in Henderson, proves to the epidemiologist here that this is a company-wide concern. So he's given me the first opinion, that hydrazine was the cause of the outbreak. He's followed up and said that this is the smoking gun. Their own testing is the smoking gun. Is that the third one, or is there one more? I think there's one more. Maybe that little quickie one in the middle is there. Okay, so in the event, we file a motion for summary judgment against Real Water, because this is their guy. This is their guy who's actually, he's saying it better than our epidemiologist says it, that it's hydrazine causing the outbreak. Okay, so we take his deposition, and again, as soon as we saw the report, I figured, well, we're never gonna see this guy at trial, so I took a trial deposition of this guy. I laid the foundation. I got all the opinion from him. And that's what this is right here. And so now we're filing a motion for summary judgment against Real Water, because how can they have their own epidemiologists say that hydrazine is the cause of the outbreak, and now they want to get up and defend these cases and say, oh, it's not the cause, it's something else. So now we get to their argument. Their argument is that, oh, Judge, there's two kind of cases here in front of you. And there are. There's 7 plaintiffs. There's only one outbreak case here, which is the Ryerson case. Okay, so they're saying, all right, this opinion just went to the outbreak cases. It didn't go to the other 6 plaintiffs, so no summary judgment. Well, you know, that's a credible argument in some ways, but first of all, they should just admit that I get a summary judgment on the Ryerson case. That's the death case. You know, this is their own witness. So they should admit that. So that's one possibility. But then they say, oh, his opinion didn't apply to all the plaintiffs in this case. Okay, Shane, can I have that section of the testimony?
Which one is that?
It's in the reply on page.
It's in the middle of 4. Middle 4 of the reply.
Okay, can you blow that up, please? So this is his deposition testimony. My opinion applies both to the outbreak, and again, that's the 21 outbreak patients, including Ryerson and Rand and some others that I showed you the MMWR this morning on. My opinion applies both to the outbreak and the group of plaintiffs in the case. Okay, so now they're telling me, well, why doesn't this get us there all the way on the summary judgment? They go, well, he didn't really mean the group of plaintiffs in this case. It was a group of plaintiffs in some other case after I filed a motion. So now they're arguing that his epidemiology opinion, that he's the expert in this case. They've tendered him in this case. He says in the deposition it applies to the group of plaintiffs in this case. Hydrazine was the cause. But now they're saying, oh, no, we get to defend the case by saying it's some other cause. Your Honor, I just don't think that's appropriate, and I'm not contesting.
Have they teed up another cause?
No, he doesn't have any other cause. If you,
I mean, you know, Williams wasn't my case.
Right, Williams was your, well, the part that got affirmed was your case.
Yes.
The part that got reversed was Judge Wade's
Yes,
case.
but you know where I'm going.
Yeah.
Yes.
Mm-hmm.
I mean, I understand independent alternative causation, plausibility theory, and I understand cross-examination. I get that. And that was discussed in great detail in Williams.
Right, and he does not tee up another cause. In fact, in that section I showed you earlier, he says unless the water people come up with some other objective evidence of cause, I'm sticking with hydrazine. To date, the only objective evidence of any cause, when I say objective evidence, I'm not talking about the wild speculation of the experts. The only objective evidence through testing by either the FDA, by the plaintiffs, or by any of the defendants, the only thing anyone has found in this water or the concentrate that causes acute liver injury is hydrazine. They haven't found any other pathogens You know, they speculate, oh, the fill machine wasn't hooked up right, it didn't have a light on it, there must have been 200 different kinds of unknown pathogens. A lot of speculation, okay? No objective evidence. Not one single test done by anybody, including the government investigators, the plaintiffs, or the defense, has found anything but hydrogen. That's the only cause. And that's why he's saying it's hydrogen. And you know, to his credit, he's saying that. But for that reason, Your Honor, based on that testimony, as to real water, we should get something.
Thank you, sir.